Good morning. I hereby call to order the 17th meeting of the Pennsylvania Public Utility Commission for the year 2019. And I ask that you please stand for the Pledge of Allegiance, which will be led by April Stover, I'm sorry, from our TUS Bureau. Thank you. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice. And we do thank April she has led us in our pledge several times over the years during our Veterans Day remembrance, and we thank her for her service to our country. As a reminder, I also want to let you know that we do have our safety information that is printed on the inside of our agenda in case we would need to leave this room during the meeting. Also, that the Commission will act on various matters at today's meeting, which is open to the public. However, since adequate forums have been made available for public participation in the cases before us, there is no opportunity for the public to address the Commission at this public meeting. Before we move on to our first matter, you see that we have a new face up here on the dais. As you know, last time we did have the swearing in of our new commissioner, Commissioner Ralph Unora. So we want to continue to congratulate him for coming onto the commission as the newest member, but also to just make note that he is here in his new seat with us today. And I just want to turn it over to him for a few comments if he would like.
Thank you. I would just like to take this opportunity to thank Governor Wolf for nominating me to the commission and for the Senate leadership for their support during the process. And I'd further like to thank my family, and I look forward to working with my fellow commissioners and my staff. Thank you.
Thank you very much, Commissioner. Our first matter on this morning's agenda is the approval of the minutes for October 3rd, 2019, and I will call upon Commissioner Place, who is the editor of the minutes.
Thank you. I've reviewed the minutes of the October 3rd, 2019 public meeting and move that they be approved as submitted.
You have heard the motion. Is there a second?
Second.
Second by Vice Chairman Sweet. Any discussion? Hearing none, all those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Now we will call upon our Secretary, Rosemary Chiavetta, to lead us through this morning's agenda.
Good morning, Madam Chairman. Good morning, Commissioners.
Good morning.
Good
Welcome,
morning.
Commissioner Unora. Your various bureaus and offices present the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by Director Monahan and the Bureau of Audits. It is recommended that the Commission release the audit report and implementation plan of UGI Utilities.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Coleman. Any discussion?
Yes, I have a statement on the matter.
Commissioner Place.
Thank you very much. Secretary Chiavetta, I ask that my statement be placed into the record as if I had read it in its entirety. Before the Commission, Pennsylvania Public Utility Commission, for release to the public is the management and operations audit of UGI Utilities Incorporated, including both gas and electric operations, UGI Central Penn Gas Incorporated, and UGI Penn Natural Gas. UGI's implementation plan indicates agreement with 42 recommendations, partial agreement with 1 recommendation, and disagreement with 2 recommendations. Several of the staff recommendations, if implemented, could yield qualitative and/or quantitative benefits. UGI's combined quantifiable annual cost savings are estimated to be between $336,000 and $713,000, whereas one-time savings are estimated to be between $3.4 million and $7 million. One recommendation, which UGI has not accepted, is a recommendation to update its affiliated interest agreements on file with the Commission. Audits found some agreements no longer meet the minimum standards for adequate documentation. AIAs should explicitly identify current legal entities and document the services provided, as well as the associated costs, in sufficient detail to properly inform the Commission of its activities with the company's affiliates. I encourage the company to work with audits and technical utility services to ensure that all AIAs on file with the Commission meet current reporting standards so as to be compliant with the directives of this Commission. Thank you.
Thank you, Commissioner Place. Any further discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended in an omnibus motion that the Commission release the audit reports of the Newtown Artesian Water Company appearing at the bottom of page 1 and continuing to include the report at the top of page 2.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 3, in matters presented by Director Sophie and the Office of Special Assistants, it is recommended in an omnibus motion that the Commission adopt both items appearing on page 3, beginning with the complaint of Janice Denito Brana versus the Pico Energy Company, and continuing to include both items on page 4, both items on page 5, both items on page 6, both items on page 7, both items on page 8, and ending with the single item on page 9, the complaint of the Bureau of Investigation and Enforcement versus Herbert Joseph doing business as J.N. Limousine.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 10, and matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt in an omnibus motion all of the items on page 10, beginning with the modification of smart meter baseline provisions proposed by the First Energy Companies, and continuing to include all of the items on page 11, all of the items on page 12, both items on page 13, all of the items on page 14, both items on page 15, both items on page 16, and ending with the first item on page 17, the petition of PPL Electric Utilities.
Is there a motion to adopt staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Finally, on page 17, it is recommended that the Commission release the quarterly earnings report of Pennsylvania Utilities.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yunora. Any discussion?
Does I have a statement on the matter?
Commissioner Place.
Thank you. Secretary Chiavetta. So my statement would be placed in the record as if I had read it in its entirety. Before us today is the report by the Bureau of Technical Utility Services to the Commission regarding quarterly earnings of Pennsylvania utilities for the quarter ended June 30, 2019. This commission proposes to retain the proxy return on equity for electric, gas, and water of 9.55, 10.00, and 9.95%, respectively. I continue to oppose these proxy ROEs as they lack empirical justification and exceed industry average ROEs, despite a very low risk and attractive cost recovery climate in the Commonwealth. For electric utilities, the discounted cash flow analysis indicates an ROE of 8.31% with a one standard deviation of 7.05 to 9.56%. The proposed proxy ROE of 9.55% is 124 basis points above the DCF determined ROE, while a capital asset pricing model analysis produces a 7.74% ROE, providing a reasoned directional confirmation of the DCF analysis. Additionally, national rate case ROEs have declined from 9.43% to 9.38% from 2017 to 2018. Lastly, since first quarter 2018, DCF analysis-based ROE estimates have dropped 90 basis points, while CAPM analysis-based ROE estimates have dropped 127 basis points, while this Commission's proxy ROEs have moved downward only 10 basis points. Thus, all empirical indicators, DCF, CAPM, actual rate case ROEs, as well as recent changes in DCF-based ROEs from the Commission's quarterly earnings reports, support a lower industry proxy ROE. Consequently, in the interest of gradualism, a 10-point basis reduction in the proxy ROE for electric utilities is not only overdue, but rationally necessary. I would also encourage further reductions if market fundamentals remain relatively constant. For natural gas distribution utilities, DCF analysis yields an ROE of 9.27% with a one standard deviation of 7.9 to 10.63%. The proposed proxy ROE of 10.00% is 73 basis points above the DCF determined ROE, while the capital asset pricing model analysis produces an 8.46% ROE, providing a reasoned directional confirmation of the DCF analysis. Analysis by S&P Global Market Intelligence's Regulatory Research Associates notes that the average gas utility ROE authorized in cases decided during 2018 declined to 9.59% versus this 9.72% average for cases decided in 2017. Thus, the proposed proxy ROE is already well above the industry average, despite, again, a financially supportive, low-risk regulatory environment in Pennsylvania characterized by multiple pass-through riders and a distribution system improvement charge to mitigate rate case lag. Again, I note that the financial risk of Pennsylvania's natural gas distribution companies is also relatively lower than national average industry averages, with average common equity ratios of 54.01%, compared to national industry average equity ratios of 50.09% in 2018 rate cases. Despite this empirical view, this Commission now proposes to maintain the natural gas proxy ROE of 10.00%. Given relative ROEs across the country, comparative low financial and regulatory risk for the Pennsylvania NGDCs, combined with supportive DCF and CAPM analyses, a 10-point basis point reduction would be appropriate, being mindful of the value of gradualism. I would, however, recommend further reductions in proxy ROEs in 10 basis points increments for the gas utility companies, assuming market fundamentals remain relatively constant. For water utilities, the base DCF calculation is at 9.18%, a further decrease of 13 basis points from the last quarterly report, and a 50 basis point drop since first quarter 2018, with a rather wide one standard deviation of 7.95 to 10.39%, and a corroborating 8.62% CAPM result. The existing proxy ROE of 9.95% is already 78 basis points higher than the DCF-based ROE calculation, and 133 basis points above the CAPM calculation. In addition, as I've previously highlighted, investor-owned water and wastewater public utilities avail themselves of acquisition premiums and fair value rate-based valuations when they purchase municipal and municipal authority systems. And the same investor-owned public utilities can rate-base the cost of lead service line replacements and damaged wastewater laterals, where the quarterly DISC ROE will play a role. Awarding ROEs that are 78 basis points above the computed and market-based numbers overcompensates investor-owned public utilities in a number of areas. Consequently, a minimum 10 basis point reduction in the water utility DISC ROE to a 9.85% figure would be empirically sound and economically wise, as I would hope the Commission would transition to lower and more just rates. Notably, the arguments I make here are buttressed by S&P's Regulatory Research Associates Global Market and Intelligence Report of September 6, 2019, which highlighted the very generous stockholder climate created by regulatory policy in Pennsylvania. In light of continued constructive developments, this research firm raised the ranking of Pennsylvania regulation to above average 2, the second highest ranking. Generous and low-risk policies employed in Pennsylvania include, but are not limited to, an October 2018 decision authorizing a 9.85% ROE for UGI Utilities electric operations, which was considerably above average annual nationwide ROEs. ROEs approved through the Commission quarterly earnings reports in recent quarters have exceeded nationwide averages. The Commission allows for the use in general rate cases of fully projected future test year. Most utilities have DSICs allowing quarterly rate updating on infrastructure investments between rate cases, thus mitigating regulatory lag. Retail competition in place since 2000 and a post-transition default service supply framework that insulates electric and natural gas utilities from the risk associated with the market price fluctuations. The Commission has not generally imposed onerous ring fencing or rate-making conditions on proposed mergers. The deferral of storm costs that are incremental to the level recognized in base rates, with a recovery of deferred balance to be addressed in the company's next base rate case. This Commission has allowed companies to capitalize the implementation costs associated with cloud-based computing programs and with updates to billing systems, items that are usually expensed. Act 58 of 2008 gave the Commission the authority to approve alternative rate-making mechanisms proposed by energy and water utilities. Such mechanisms include, but are not limited to, revenue decoupling, performance-based rate plans, formula rates, multi-year rate plans, and a framework incorporating a portfolio of alternative mechanisms. Natural gas utilities may retain up to 25% portion of the benefits associated with capacity release and off-system sales. Electric distribution companies have mechanisms in place to allow changes in FERC-approved PJM transmission charges to be automatically reflected in rates. EDCs can also recover costs associated with smart meter deployment plans through a rider between rate cases. Riders are also in place for universal service costs and approved energy conservation plans. In summary, an above-average 2 designation indicates that, in RRA's view, Pennsylvania's regulatory climate is relatively more favorable than average, representing lower risk for investors. Only one state has a higher ranking, Alabama, and 4 other states have the second highest ranking out of 53 jurisdictions. Despite demonstratively empirical analysis, all these risk-reducing and profit-enhancing policies and investment analyst confirmation of our low-risk regulatory environment, this Commission continues to grant above industry average ROEs. I support the public release of the staff report, which is thorough and comprehensive. However, for the reasons stated, I will be in opposition to the motion to adopt the Commission-proposed electric, natural gas, and utility proxy ROEs. In contrast, a 10% basis point reduction for each industry sector would be just and reasonable. This isn't simply an esoteric academic abstraction. For example, residential electric prices in rank order from the least expensive to most expensive, Pennsylvania ranked 21st in 2017. However, by August of this year, the average Pennsylvania residential electricity price has risen to 13.83 cents per kilowatt hour, moving Pennsylvania's rank towards the back of the pack at 35th nationwide. Ratepayer costs in Pennsylvania are substantial. Overly rich ROEs contribute to this drag on business and household economics. Thank you.
Thank you, Commissioner Place. Any further comments? Hearing none. All those in favor say aye.
Aye.
Any opposed?
Opposed?
The motion passes 4-1, noting the dissent of Commissioner Place.
Turning to page 18 and matters presented by Chief Counsel Hicks and the Law Bureau. It is recommended in an omnibus motion that the Commission adopt both proposed orders regarding the Pennsylvania Universal Service Fund and the petition for reconsideration and rescission filed by MX LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second?
Motion by Vice Chairman Sweet, second by Commissioner Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Turning to page 19 and matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt A.L.J. Watson's initial decision in the complaint of Jerome Syndico versus PPL Electric Utilities.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second?
Motion by Vice Chairman Sweet, second by Commissioner Coleman. Under discussion, I do have a motion, so I'm going to ask, Vice Chairman Sweet to preside.
I will do that.
I'm
Thank you,
always
Madam
just
Chair.
moving this thing over towards
Yeah,
you.
no, I don't, I don't want to get when you swing that thing so hard.
Practice.
I get concerned about my fingers. In any event, Madam Chair, you are recognized. Oh, excuse me, let me recognize Commissioner Yanora first. He has a statement.
I will need to recuse myself from this matter because I worked with the city of Pittston while the complaint was pending.
Thank you, Commissioner Yanora. Madam Chair, you're recognized for the purposes of offering your motion.
Thank you. I ask that my motion be spread upon the record in its entirety. Before the commission is the complaint of Jerome Sindacco alleging that PPL improperly disconnected service to his rental property without appropriate notice. PPL admitted that it terminated service to the property when a Pittston zoning code enforcement officer informed the company that the property's electric service was unsafe. By initial decision issued October 30th, 2019, the ALJ determined that PPL violated Section 1501 of the code when it terminated service based on a phone call from a code enforcement officer. The ALJ also determined that PPL violated Section 56.71 of our regulations by failing to provide or attempt to provide notice of a termination to any adult occupant of the premises. The ALJ imposed a civil penalty of $2,000 for these violations. The record shows that PPL terminated service to the property to eliminate an imminent threat to safety or substantial property damage. Because PPL's action was reasonable, there was no violation of Section 1501 of the code. Although PPL's termination of service was reasonable, as PPL's witness testified, in circumstances such as this, the utility does not notify building occupants. While I understand that PPL notified the building's owner of the termination, PPL's lack of notice to the building's occupants is a violation of Section 56.71, Section 2 of the Commission's regulations. PPL is advised that it must revise its operating procedures to ensure that both customers and property occupants are given notice of termination consistent with our regulations. A civil penalty is not merited in this instance, but a failure to give appropriate notice in the future would result in the imposition of civil penalties. Therefore, I move that, 1, the initial decision be sustained in part and reversed in part, consistent with this motion, and 2, the Office of Special Assistance draft an opinion and order consistent with this motion.
Thank you, Madam Chair. Is there a second to the motion?
Second.
Seconded by Commissioner Place. It has been properly moved and seconded. Is there any discussion? Seeing no further discussion, I will call the vote. All those in favor will say aye.
Aye.
Aye. Those opposed? The ayes have it 5-0.
4 to 0.
4-0.
4-0.
4-0,
You are
noting
correct because Commissioner Yanora
Yonor's
recused himself.
recused.
Thank you very much for that correction. We will take the same vote on the matter as amended without objection. Seeing no objection, there'll be a 4-0 vote on the final matter. I yield back to you, Madam Chair.
Thank you, Vice Chairman Sweet. Turn it back to our secretary.
It is recommended that the commission adopt ALJ Calvelli's initial decision in the complaint of Carl Lasserre versus the Metropolitan Edison Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yanora. Any discussion?
Madam Chair, I have a motion.
Vice Chairman Sweet.
Thank you. Before the commission is the initial decision of Administrative Law Judge Andrew Calvelli dismissing the formal complaint filed by Carl Lasserre against Metropolitan Edison Company. The issue is whether MedEd's denial of service to Mr. Lasserre, unless he paid a portion of the $9,720 arrearage of the prior tenant of the apartment up front, with the remainder to be paid in installments, was reasonable. Mr. Lasserre testified that he obtained a lease for the apartment in January of 2018 and did not live there prior to that time. Excuse me. Med-Ed maintains that he lived there with his mother since 2010 and therefore benefited from the electric service during the intervening years. The burden of proving that Med-Ed's actions were unreasonable falls upon Mr. Lasserre, who did not provide any documentation to support his claims that he lived elsewhere during the time period in question. Because the administrative law judge did not find Mr. Lasserre's testimony credible, the judge concluded that the complainant did not sustain his burden of proof and dismissed the complaint in its entirety, thereby holding Mr. Lasserre accountable for the previous balance at the service address. A complainant must initially produce sufficient credible evidence to establish a prima facie case. Here, the complainant has not established a prima facie case. Therefore, the burden of going forward did not shift to Med-Ed to produce credible evidence of at least co-equal weight. Under the circumstances, the discussion regarding Med-Ed's presentation of evidence should not be included in the final commission order in this case. Therefore, I move that, number one, the initial decision of the administrative law judge in the case captioned Carl Lasserre versus Metropolitan Edison Company at docket number F 2018-3002862 is adopted as modified by this motion. Secondly, that the formal complaint of Carl Lasserre is denied. Third, that the Office of Special Assistance prepared appropriate order consistent with this motion. Thank you very much, Madam Chair.
Thank you, Vice Chairman Sweet. Is there a second to the motion?
Second.
Second by Commissioner Place. Any discussion on the motion?
Statement on the matter?
Commissioner Place.
Thank you very much. Madam Secretary, I ask that my statement be placed into the record as if I'd read it in its entirety. As stated, for consideration of the initial decision of Administrative Law Judge Andrew M. Covelli at docket number F 2018-3002862. At the time of the hearing on May 2019, the company indicated that it had offered Mr. Lasserre a payment arrangement on June 2018 and remains willing to provide him one a year later. The company also indicated that Mr. Lasserre did not follow up with Med-Ed to establish a payment arrangement for the balance on the account. While I support the ALJ's determination in this proceeding, I would encourage both parties to pursue any applicable payment arrangement or any other means of assistance to satisfy this outstanding balance. Thank you.
Thank you, Commissioner Place. Any further discussion on the motion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0. Without objection, we'll take the previous roll call on the motion on the matter as amended. Seeing no objections, the matter as amended passes 5-0.
Turning to page 20, it is recommended that the commission adopt ALJ Jones's initial decision in the complaint of James Schlegel versus the Pennsylvania American Water Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Sweet, second by Commissioner Place. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
It is recommended that the commission adopt ALJ Myers' initial decision in the complaint of Michael and Brenda Bloom versus the Overbrook Water Company.
Is there a motion to adopt staff recommendation?
So moved.
Second.
Motion by Vice Chairman Sweet, second by Commissioner Place. Under discussion, I do have a motion, so I ask Commissioner Place to preside.
Vice Chairman.
I mean,
Sweet.
yeah.
It can go either way, but I think.
Look, you know, I screwed up a little bit, said 5-0 instead of 4-0. Now I get bounced. Okay.
I am in my zone, and I
Tough-
just throw all kind of names out
Tough
there.
chair.
It's a coup.
Someone please preside while I offer my motion.
Let's put some pressure on Commissioner Yenora and let him preside.
We'll give it a shot.
I'll take control here.
Okay, dude.
And Madam Chair, you are recognized.
Thank you. I ask that my motion be spread upon the record as if I read it in its entirety. Before the commission is the formal complaint of Michael and Brenda Bloom versus Overbrook Water Company. In their complaint, the Blooms contend Overbrook failed to provide reasonable and adequate service to their residents. As a remedy, the complainants request that the commission force the sale of the company to a competent utility or impose a fine. The record indicates that the Blooms began to experience water service issues in March of 2018. Details in the proceedings show that the complainants experienced at least 10 instances of low water pressure and main breaks from March 2019 to July 2019. The presiding administrative law judge dismissed the complaint. The ALJ acknowledged the water service problems, but also avers that neither the Public Utility Code nor Commission regulations requires flawless service. Further, the initial decision notes that Overbrook has exhibited continued efforts to respond to the referenced service issues. In conclusion, the ALJ contends that the Blooms have failed to show the company's service issues rise to the level of unreasonable or inadequate service, and therefore there is no basis for a fine or for an investigation into the sale of Overbrook. I agree that this record does not substantiate the ordering of an investigation into the potential sale of Overbrook. However, I do not agree that the record fails to support a finding of unreasonable service. The ALJ is correct when submitting that utilities are not required to offer perfect or flawless service. Rather, the Commission requires that it be reasonably continuous. As such, the exact characterization of what constitutes unreasonable service is not black and white and can vary depending on circumstances. When applying prudent judgment, I believe the record here, exhibiting a minimum of 10 instances of low water pressure and main breaks, is reflective of unreasonable service to the complainants and therefore a violation of 1501 of our code. Water is a necessary resource for health and human safety. Therefore, the frequent service issues and interruptions detailed in the complaint are of consequence. However, there are numerous mitigating factors to consider. Overbrook's conduct in handling these service issues are not shown to be egregious, does not exhibit willful fraud, and is not intentional. Further, the record shows that the company responded in good faith to promptly make repairs. Additionally, the record shows that the company is cooperating with I&E in attempts to improve its future service quality. There's nothing on the record here that shows these service issues affected a significant number of customers. Moreover, the company's size is quite small, serving approximately 180 customers according to its 2018 annual report. Similarly, it does not appear that Overbrook customers have a history of service complaints before the Commission. Balancing the frequency of these service issues with numerous mitigating factors, including but not limited to the company's attempts to promptly remedy issues and the company's size, I believe assessing a small civil penalty is prudent. Consequently, I submit that a penalty of $50 for each of the 10 service issues presented on the record is warranted and consistent with the code and regulations. This results in an overall civil penalty of $500. Therefore, I move that 1, the initial decision be modified consistent with this motion, and 2, the Office of Special Assistance draft an opinion order consistent with this motion.
Thank you, Madam Chair. Is there a second?
Second.
It has been properly moved and seconded. Is there any further discussion? Seeing none, all those in favor will say aye.
Aye.
Aye. Opposed? Hearing none, the motion is carried 5-0. Without objection, we will have the vote on the matter as amended, also recorded at 5-0. Thank you very much, and I yield back to you, Madam Chair.
Thank you, Vice Chairman Sweet.
And finally, on page 20, it is recommended that the Commission adopt ALJ Brady's recommended decision in the matter of I&E, OCA, and OSBA, and Gary and Mary Kutzelman versus the Community Utilities of Pennsylvania.
Is there a motion to adopt staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Place, second by Vice Chairman Sweet. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman, that concludes regular agenda. Turning to the carry-in agenda, it is recommended by the Law Bureau that the commission adopt in an omnibus motion both proposed orders regarding the petition filed by Columbia Gas of Pennsylvania and the petition filed by Innova Energy LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor say aye.
Aye.
Any opposed? The motion passes 5-0.
Madam Chairman and Commissioners, that concludes all items to be considered today.
Thank you very much. We do want to note before we adjourn for the day that there is a reception for Commissioner Yunora after we finish to welcome him once again to the PUC. Also, we want to note that today is part of our observance of Veterans Day, and we invite you to stay after we gavel out for our annual program. Without objection, we are adjourned.